Hi, this is Rahul Reddy from Reddy and PC. Along with me is my business partner, Ren. Ren, we're discussing about the downgrading of EB-2 to EB-3. If I have an I-140 approval under EB-2 and the priority dates are becoming current for the EB-3, can I downgrade from EB-2 to EB-3?
Essentially, yeah. The easiest way to think of it is that if you've got an EB-2 approval, you can almost always downgrade that approval to EB-3 category.
So do you have to file another labor certification and I-140 again, or can we use the same old labor certification?
You are entitled to use that old labor certification. So the labor certification that you use to get your EB-2 approval, you use that same labor certification to apply for the EB-3. And now you might think, hey, that labor certification is expired. It expired years back. That's fine. The rule for USCIS is once the labor certification is approved, you have a 180-day window. As long as one I-140 is filed within that 180-day window, it effectively makes the labor certification good forever. So if you want to refile the same I-140, if someone leaves the company and you have to refile it, or in this case, if you want to do a downgrade, that labor certification is going to be good forever.
Ren, you told me that when somebody needs to upgrade from EB-3 to EB-2, you have to file a perm labor again because the documentation was done differently when you want to upgrade from EB-3 to EB-2. But when you want to downgrade it, don't the requirements are suitable only for EB-2 and not for EB-3?
You can sort of think of EB-1, EB-2, EB-3 as what are the minimum requirements? What do I need to get into this club? For EB-2, it's generally a master's degree or a bachelor's degree plus 5 years of experience. Whereas in EB-3, you can have as little as 2 years of experience or generally just a bachelor's degree. So that's the minimum that we have to meet for EB-3. If you look at your EB-2 labor certification, that bar is going to be this much higher. It's going to be the master's degree. It's going to be the bachelor's degree plus 5 years of experience. So the requirements for your EB-2 labor certification will always be above the minimum requirements of the EB-3. So if the labor certification says this individual has to have a master's degree or a bachelor's plus 5, that requirement will always meet the bare minimum of either a bachelor's degree, no experience required, or a minimum of 2 years experience. So if you've got an EB-2 approval, 99.9% of the time, you will meet the requirements of the EB-3 requirement.
Okay. And
so, Rahul, if the priority dates are coming closer to the EB-3 today, do you recommend I file the downgrade, or would you wait until the priority dates become available?
So if they are not current right now, but maybe in future they are going to become current, I do not recommend people filing the downgrade right now. They can always file it when the priority date becomes current. They don't have to do it in advance. I would strongly recommend that people contact the employers and make sure the employers are willing to downgrade the I-140 application. That is the best thing that you need to do. You don't have to downgrade immediately. You can do it when the priority date becomes current.
And just one additional bit for these employers. The cost is the filing fee of the I-140. There really is no additional hoops that they have to jump through. They still look at ability to pay in the same way. It's essentially that same EB-2 that you did. That's the lens that will be applied to the EB-3. So if you're thinking, my employer might be concerned about a number of things in the background, there are no background. They've done what they need to do for the labor certification, and the government will have no issues downgrading that EB-2 to the EB-3. So Rahul, we're getting close to the priority dates. We think the priority dates might be coming current. Say the priority dates do become current. Are we going to have enough time to get the I-140 approved? I mean, we know that priority dates often retrogress. What impact would that have?
Well, you don't have to get an I-140 approval under EB-3 to file an adjustment of status though. If the priority date would have been current under EB-3, we can use the I-140 approval of the EB-2, an I-140 application that you're going to file with the immigration, file the I-140 downgrade application along with the 485 application at the same time, even though the I-140 for EB-3 is not approved.
So let me understand this. I have an EB-2 approval. My priority date is not current.
Right.
But that same priority date would be current in EB-3.
Yes.
I can just file an EB-3 I-140?
Without the approval, you can attach the 485 application, file both of them together if the priority date is current.
Perfect. And so would you recommend that we go for premium processing in this sort of case, or do you think that normal processing of the I-140 would be fine?
Based on my experience, I strongly recommend people to file under the normal processing initially when they file the application. Because pre-COVID, we used to have the original labor certification. This labor certification was approved long time ago. So when the Immigration Service sees that there is no original labor certification, they may deny the premium processing. At the time when they deny the premium processing, they might send the I-140 application back, they might send the entire 485 application back. And by the time we send it back to them saying, hey, please consider normal processing, the priority date might retrogress. So I strongly recommend people to file in the normal processing. And once you get the receipt notice of the I-140, you can convert into premium processing at that point of time. And we have seen that they have honored the premium processing even though the original labor certification was not there, as long as the original labor certification was sent to the USCIS at the time when we filed the I-140 under EB-2.
Way backward, yeah.
Way backward. So there are so many cases that we worked and we have filed I-140 downgrade and 485 at the same time. We have had no problems. As Ryan was telling that the process for the EB-2 bar is very higher and the bar for the EB-3 is lower. Since you already met the EB-3 bar, to get the I-140 under EB-3 is not that difficult at all. We have done many times and got the I-140s approved under EB-3 with the 485 application at the same time filing. Had no problem, none whatsoever at all as of now.
Correct.
Anything else you want to do before we conclude this?
Nothing more to add. Our website does have a few articles on this if you were looking for more information. And as always, feel free to join our conference calls and our weekly videos. And as always, we appreciate your attendance.
You can always make an appointment with Ryan or me or anybody else in our office at rnlawgroup.com and strategize the policies with regards to how you want to proceed with regards to the downgrading from the EB-2 to EB-3, the timing, at which timing you need to. Please note that this process of the I-140 belongs to the employer. You cannot do it by yourself. It has to be done by the employer. Your employer has to sign and has to do all the things. It's always advisable that you contact the employer to make sure that the employer is willing to do this activity or not. You can send our video to him and have him in the HR or the company to see our video to see what are the steps that are involved in downgrading from EB-2 to EB-3. Thank you guys for tuning in.
Thank you.
Thank you.